go and take my seat to introduce my non-germane amendment, and Vice Chairman Bohm will lead us, and then at 270, and then at 10, I'll take the chair back and we'll do SB 271. So I'll see everybody right over there. Okay, I don't know why it's not with us. I'm sure our researchers will get it to us soon. I'm going to introduce let me read the number here. Hold on. A little disjointed today. The kid was up at 2 a.m. Well, yeah, so I'm like, I'm waking up. I'm just not there yet.
Oh.
And then there's 2 meetings this morning, and my brain is just it's just not where it should be. Let me grab. Hold on. I don't have it. Okay. All right, here we go. All right, so introduce Amendment 2023-1362H, which we've seen before. We retained. It moves the primary date to June. So to just kind of give the background about why I'm doing this, it is not about moving the primary date to June. I am open to conversations about what day to move it to. I am a publicly supporter of June, but I have voted for August. I would support May. I'd support basically anything that's not where it is now. That's not moving it back just 1 week. When we retained the original bill that we submitted to the committee, the idea was the Senate would act, and then the Senate does what the Senate does and did not act. And very opposed to changing the primary date in the year that the primary is happening. That's kind of a no-go. We've traditionally in this body not made substantive changes to election law that applied to the election that was immediately happening that year. And there's numerous examples of that. SB 418 with the affidavit ballots, we pushed off till after the election. This is an attempt to keep this alive. I'm happy to answer any questions about, why we need to move it. I'm definitely going to be excited to hear where people think it should be, but I'm not stuck on June. I'm not against August. We just need something to keep it alive because the Senate has not done their job, and per usual, that means the House has to do the work. So it's a long shot, but you miss every shot you don't take. So,
I have any questions? Representative Kennedy.
Hi, Ross. What are your main reasons for wanting to move it earlier?
Yeah. So it's very simple. Let's take this last election, which happened about 6 weeks before the general election. So let's put the election into a timeline, right? So we file in June, yay. That's the official beginning of an election. I take issue with that. Excuse me. Excuse me. I take issue with that notion to begin with, because the concept that somebody running for governor is going to wait till June to start is laughable. I will note that the nominee for U.S. Senate for the Republican Party in 2022 started running 3 days after his loss of 2020. So they don't wait. This concept that there's this magic date that they wait is kind of ludicrous to begin with. But when you take it into context, right? So let's say we have a hypothetical situation where we have an incumbent governor. So that incumbent governor is probably not going to be primaried. If they are primaried, it's going to be nominal at best. We've seen that in late, and the incumbent governor always gets over 85% of the vote. The primary is a joke. So what does that incumbent end up doing? Well, incumbent ends up spending that entire period campaigning to the general electorate, right? So they're talking to the voters that they need to win, which is more voters, versus let's say the other party has a primary. Well, there's an expression in politics: you have to win game 6 to get to game 7, right? So does that other party get to campaign to the general electorate? No, they have to campaign to their primary base all the way until September. So there's a couple of things that happens with that. You can make arguments for or against about candidates running to their various bases and the pivot. But the reality is it's inherently a disadvantage that the non-incumbent gets to campaign to the general electorate for 6 weeks, and the incumbent gets to campaign to the general electorate for 6 months. So let's put things in, but let's go further into a timeline here, right? When do we send out absentee ballots? We send out absentee ballots. The first absentee ballots go out 45 days before the election. UOCAVA goes out 45 days before the election.
Sorry, this is not posted until 10.
No, this is 9:45.
Oh, yes.
9:45.
Okay, I'm sorry.
All right. This, we continue. So 45 days before the election, the absentee ballots go out, right? So let's put this into a timeline. So that means that the first 5 days before the election, right? Because UOCAVA ballots are emailed, right? So they literally get them instantly. So they fill them out, they drop them in the mail. So 45 days out, the first votes in New Hampshire are being cast. The primary was decided 2 weeks before that, at best. 2 weeks. So if you are a non-incumbent candidate, you've had 2 weeks to campaign to that general election voter. 2 weeks. So does anybody here truly believe that in 2 weeks you can go from running a primary campaign to a general electorate campaign when votes are starting in 2 weeks? So when you ask, why do we desperately need to move it? We desperately need to move it because 2 weeks is not enough time to make your pitch to the voters. It's bad for democracy that we have it that close because both sides are not able to actually deliver their message, right? The base hears one thing, right? The general electorate hears another. And they'll say, it's not that they'll change policy positions, but the messaging will be different, right? So if you're running in a Republican primary, you might talk about things like, guns or you're pro-life. If you're running in the Democrat primary, you may talk about how you are opposed, you want to pass gun restrictions and you're pro-choice, right? And then you get to the general electorate and you may want to talk about taxes or you may want to talk about, parental rights or protecting students, whatever it is that the base may like and the general electorate may like, but they're not aligned, right? So the candidates may not be, not that they're in disalignment, but the messaging is different. And 2 weeks to deliver a new message or a message that more rounds out the candidate is not fair. And also the thing I would point out is there's no debates, right? So you have those general electorate candidates are now unvetted. So people are voting on unvetted candidates. The only debates that have been taking place were debates on the primary. So once again, they were debates to issues of the debates, and not issues that concern to the general electorate as a whole. Moving the primary date is so important. The reason we had the late primary date was the previous Secretary of State Gardner had this vision. If anybody kind of worked with him, you knew he was obsessed with this thing called the VAP, VAP, voter age participation. He believed, I believe wrongfully, he believed that the late primary was the reason we had a high voter turnout, a high VAP turnout in the general election. I fully disagree with that assessment. Having studied the American electorate for years, that's what my degree's in. This is a statistical study of American political behavior. The late primary was not why New Hampshire has high voter turnout. New Hampshire has high voter turnout because, number one, we have hotly contested close elections. When people think their vote matters, when they think their votes might make the difference between candidate A or candidate B, they are far more likely to vote. Number two, education. This is one of the highest educated states in the country. Number three, income. The higher the income, the more likely somebody is to vote. This is an upper income state. And the one that's uncomfortable but is true is that white. If white voters tend to vote more than voters of color, and this is an 89% white state. So you take those four things together, race, income, education, and closely contested elections, that makes for a high turnout election, not having a late primary. So for years we had this late primary because that was the mentality, was that it was turning up, it was increasing voter turnout. It's based on nothing. There are states that have, every year we get that thing from the Secretary of State about the VAP, and New Hampshire's always in the top three, right? Like Wisconsin's up there or whatever. It literally has nothing. Like you look at those other states, their primary is not in September, yet they have high voter turnout because they have similar characteristics. So we need to move it. Just to kind of wrap all this up, we need to move it. I'm not stuck on June. I'm definitely open to other dates. I have voted for August in the past, but this is our last opportunity to try to get this done this year, because basically if we don't do it now, I can't support moving the primary date inside the election window, and we'd have to do something like kick the can down for another 2 years. And I really don't think we should wait on this anymore.
Thank you. So can you tell me when those other primaries are in the top three states with voter participation?
Not off the top of my head, but I
can.
can tell you where we rank in the country. So we rank last. We are last in the last primary to go. Us and Rhode Island. Sometimes Rhode Island will like be really. If you want to model New Hampshire after Rhode Island, go for it. But sometimes Rhode Island will go after us, but usually it's us and Rhode Island are the last. August and June kind of puts us in the middle. May has been thrown out there, and at that point, like even I start getting uncomfortable. Like May's kind of early. There are states that conduct their primary in the odd year. I would never recommend that. That's probably on the other end of the extreme. There's states that have a primary in December of the odd year, which is kind of wild. But it just kind of shows you how late we are, right? That we're doing it 6 weeks before the general election, and there are states that are like, no, we don't even do it in the year.
Any further questions? Follow up?
Yes, follow up. Thank you. So I would really like to know those primary months that those other states that have high turnout have. When you're saying also, this is the follow up, to vote for this, even though it's June, if you're more inclined to say August, this would get you there. If we, is that what you're saying? Is that
Yeah,
you're so
well-
open to amendments?
Oh, I am definitely open to this. My point of the amendment is to keep the discussion alive. I did make a mistake in that I thought that the underlying bill was a unanimous bill, and it turns out it was a partisan bill. So I am toying in my head. I told you guys I do not want to recess a bill. I am toying in my head with recessing the bill to have the amendment replace the entire bill, just to make the conversation easier. But that's a conversation we'll have during exec. If there's zero interest, then I'm just chasing a ghost here. Then we'll just move on. That's okay. You don't win them all, but it's we have to keep it alive. I needed something to keep it alive, and I got this amendment in with 2 minutes to spare. So it wasn't. I didn't have a whole lot of time to call around and say, "Hey, what do you want to do?"
Representative Lane.
Mr. Chair, we have retained a bill on this, correct?
Correct.
Follow up?
Follow up.
And can you explain one more time why you don't want to just work on that retained bill?
Yeah, because I want to get the date changed for the next election, and we cannot touch that retained bill until January. So I do not want to change the 2024 election in the year 2024. If we're going to change the 2024 election, once again, to be fair to the candidates, right, and our voters, by the way, we need to change it in 2023. So, the alternative plans would be to bring that retained bill back and pump it back to 2026. But we've been talking about this now for a long time, and we just need to keep the conversation alive. And like I said, we'll talk about it during exec, but I am totally open to ideas to keep it alive in 2023, because once it gets to 2024, it's going to become much more of an intellectual exercise.
Representative Brennan.
Thank you, Mr. Chair. And thank you for taking my question. Am I understanding your testimony correctly to be that one of the main reasons for your amendment and moving the primary date is to accommodate candidates who are unable to pivot their messaging from the primary to the general election? And is that a legitimate reason to move it?
All candidates pivot, all of them, both parties pivot. You can't do it in 2 weeks. So if you have an incumbent, right? I am not into protecting incumbents. I've said that many times. I consider our current primary the incumbent protection plan, right? So the incumbent gets to message to the general electorate for 6 months, and the challenger gets to message to the general electorate ostensibly for 2 weeks because voting starts 2 weeks after their primary. So even if the incumbent gets to run a general election strategy from the beginning, challengers have to run a primary strategy. Once again, got to win game 6 to get to game 7. And then they have 2 weeks to try to make a pitch to general election voters. They're not even communicating. It's not. I understand you're probably thinking about the message. I'm more thinking about who the message is going to. If you're in a primary and you're sending mail, you're not going to send mail to the general electorate. The general electorate is 5 times the size of the primary electorate. You're going to send mail to the primary electorate. So the only voters getting an input or receiving information from the candidates are primary voters. General electorate voters should be campaigned to as well, and they should have longer than 2 weeks to make their decision.
Follow up, please.
Follow up.
Is there anything in current statute that would prevent a candidate from doing voter outreach by retail campaigning, by door knocking, by spreading their message before the primary? And is there anything in statute that would prevent a candidate from using a consistent message through their retail campaigning that would perhaps start before the general campaign period for the primary?
Yeah, absolutely. So the first is campaign finance laws, which are you don't have access to your general election money until 6 weeks before the general election. So the general election candidate gets to spend their primary money on the general electorate, and the primary candidate gets to spend. They get to spend. So the general election the incumbent can spend their primary money on the general electorate starting whenever they want, technically June, whenever they want. The primary candidate doesn't have that luxury. They have to spend their primary dollars on the primary electorate because they need the primary electorate to win. So I'll kind of answer your question with a question. You're in a contested primary race. Let's say you and I are in the same party and we're in a contested primary race. It'd be an interesting primary, that's for sure. I spend my entire time talking to the primary electorate, and you spend your entire time doing what you just inferred, which is messaging to everybody. We go into that primary, I am going to smoke you in the primary because I have campaigned to the voters that vote in that primary, and you have campaigned to voters that have not campaigned, do not vote in that primary. Because when you go and vote in the general electorate, right, the general electorate's about 5 times the size of the primary electorate. So you're going to spend your limited resources, 4 out of 5 of which are going to go to voters who are not going to vote. Not going to say they're not going to vote for you. They're just not going to vote. I'm going to spend my resources going to the voters that vote, and we'll see who wins. It's going to be me. If the situation would reverse, it was you. If I was so foolish as to campaign to the general electorate in the primary, and we were primarying, and you went to the primary voters, you would smoke me. And we'd all sit back and they would say, why did he do that? And we'd be like, well, he wanted to win the general. But once again, you can't win the game 6 to get to game 7. You have to win the game 6. Game 6 is in front of game 7. So to answer your question, structurally, it's money. Structurally, they have to spend their primary dollars on the primary electorate versus the incumbent can spend their primary dollars on the general electorate. It's a luxury that is granted to the incumbent because the late primary is the incumbent protection plan. That's why incumbents tend to support it.
Representative Howard.
Thank you, Mr. Chairman, and thank you for taking my question. So we're talking about 2 weeks here from when people are finishing up with the primary and when they're getting their absentee ballots. And when we're looking at this, are these people filling out their absentee ballots as soon as they get them?
They certainly can. It's sent to them electronically. I voted with an absentee ballot before, and I don't get it and let it sit on my desk. But once again, I think you should have the right to vet your candidates, right? You should have the right to have your candidates campaign to you, right? I think that's an important part of it. I actually think candidates going out and spreading their message is an important part of the democratic process. Versus just you reading something on a blog or something. It takes a while. I mean, I used to work in campaigns. Thankfully, I don't anymore. It takes a while to make that pivot. You come off of primary night, you are tired. You're up till like 2 o'clock in the morning because towns like Salem don't report till 1 a.m., right? So the next day is dead. So now you're at 13 days, right? Then you have to sit around and figure out, is there going to be a recount, right? God forbid there's a recount, by the way, because if there's a recount, that 2-week window is gone. The moment we have a statewide recount in this state for a primary, which we could have had in 2016 when Frank Edelblue lost by 808 votes. The 2-week window that I've just described to you is gone. It will take more than 2 weeks to conduct a statewide primary recount. So the time window is too compressed. It's too compressed. And even you can make the argument, 2 weeks is aggressive. I'd still say 6 weeks is not enough. 6 weeks is not enough to craft a message, right? Message test, figure out what's going on, and go out and campaign. The other member talked about knocking on doors. How many doors can you knock on in 6 weeks if you're in a statewide race?
Follow up?
Follow.
Thank you. So if somebody is a huge success in the primary, blowing out all their opponents, and they end up, oh, thank you. That individual ends up having an uncontested, or their opponent has an uncontested primary. When that happens, what are what are the voters thinking when they have to now decide between potentially two candidates who haven't served in office before? They have the same time to reach people, don't they?
Yeah, so I think to get to your underlying question, there's no accounting for working the party process, right? So if one candidate can successfully convince every member of their party not to challenge them, moving the date doesn't change that at all, right? Because if that happens in June, right, if under our existing law, if that happened in June, right, the incumbent advantage, it still exists, but it's now greatly diminished. There's no moving the date that fixes that. We do know that happens very rarely. It's very rare that open seats that are winnable in the general are very often primaried, right? The seats that you see that don't have primary tend to be ones that are unwinnable for the respective party, right? So if, an example is there was a state Senate race in Salem, right? This is the most Republican seat in the state. There was no contested primary for the Democratic Party because they all knew the candidate was going to lose by 2 to 1, and they lost by 2 to 1. So nobody wanted to throw it in there. But when there's a contest, right, when that end goal is winnable, there's almost always a primary. So in that same seat I just referenced, there was a primary, right? It was an open seat, but there was a primary on the Republican side because it was a winnable Republican seat. So, but to go back to your underlying question, there is no, moving the date will not change a candidate's ability to work their own party. But you can make some philosophical statements about, are you circumventing the will of the people at that point, right? Who's really in control? That's a deeper conversation for a deeper day. But to your underlying point, moving the date will not change a person's ability to meander their own party.
Any further question? Representative Bruno O'Brien.
Thank you, Mr. Chairman. Do you think this would be helpful for college students to register to vote and get absentee ballots prior to leaving for college? I know that seems to have been a challenge in my community, watching people do that and then also try to move to college around the same time.
Yeah, I don't know if it would be, one of the objections of July is that people are out of the state. I don't know why anybody leaves New Hampshire in July. It's the best month to be here, but that's neither here nor there. But I don't think it would, keeping it in June, you're still in the college student window, right? So, I mean, I do hold a different view than many of my colleagues on my side of the aisle about college students. I think they do have a legal right to vote here. However, I think most of them are still around in June. They can still have their absentee ballots. They can definitely go get those absentee ballots in person in May. But in terms of absentee voting, the one thing that it would, and this would be true for August or any date we moved, one thing it would do is it would relieve our UOCAVA pressures that we have, and it would negate the argument of like what happens if we have a statewide recount. One of these days we are going to have a statewide recount. It is going to happen, and we are going to miss that UOCAVA date, and we're going to get sued, and then we're going to have to move it because the court's going to tell us we have to move it. Like, that's coming down the line, by the way. I don't know when it will happen. I can't tell you if it'll happen in 2024, if it'll happen in 2026, but my smart money is on it happens in the next decade. So moving the date would help with absentee ballots at a minimum because the Secretary of State's office wouldn't be drinking from a fire hydrant trying to get those things out. They'd have a lot more time to get those things out for the general election. For the primary election, I mean, they have the window's the same that they have now. They know who's running. They have time to print it up, and there's hardly ever any issues with absentee ballots in the primary. The absentee ballot issues, which are very limited, tend to arise in the general, just because things are moving so fast. Because we have 6 weeks to campaign.
Any further questions? With that, thank you. And I don't see anybody wanting to testify. So with that, I'll close the hearing on the amendment on 271.
All right, and I'm back. Thank you to Representative Aikenberg for giving me a cough lozenge. That was pretty miserable. We've closed the hearing on the non-germane amendment 2023-1362H and to SB 271. And now we're going to actually hear SB 271. We get to hear this today because we didn't take possession of the bill in time for last week. So do we have anyone from the Senate here to introduce this bill? Oh, Senator Brad. Oh, wow. We have, not only do we have anyone, we have the Senate President. Senator, welcome to, do we call you Senator or President? Welcome to election law.
Good morning, Mr. Chairman, members of the committee. For the record, Jeb Bradley from Wolfboro. I thought this was a pretty simple bill designed to protect the New Hampshire primary. I see suddenly that it may not be so simple, but we'll just discuss the intent of the bill, which the Senate did pass. It amends RSA 653.5, delegates to the National Convention, and it adds a sentence that any New Hampshire delegates that have been selected shall be seated by the National Convention and have full voting rights. That's it. Pretty simple. I think everybody knows why it's here, and I would hope that we are all about protecting the New Hampshire primary. The primary is going to happen. There will be a Republican nominee, there will be Democratic nominee, there will be delegates from New Hampshire, and at least in our law, they should have full voting rights and should be seated. So that's why I introduced it, and I commend it to you.
Will you be taking questions, Senator?
Sure.
Are there questions from the committee? I almost called you Senator King. Representative Kennedy, not just quite yet. You got to talk to him, though, if you want to do that.
I have to turn this on first. Thank you, Mr. Chairman, and thanks for taking my question. I'm a new person here, so you said that we all know why this was put in, but I don't. So could you explain what happened, what the problem was?
Really? Okay. So obviously, the Democratic National Committee has adopted rules that, in essence, say New Hampshire's first in the nation status no longer will be the case, and anybody that campaigns here, the delegates from New Hampshire for that person will be penalized. And so my view is, and I think the view of the Senate is, those delegates should be seated at the National Convention, not penalized.
Further questions from the committee? Representative Lane.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. What effect is our state law going to have on the Democratic National Committee?
I think it's probably not enforceable, but nevertheless, I think it's important for New Hampshire to do everything that we can to protect the first in the nation status. We're hearing from presidential candidates in the Senate. We passed a resolution unanimously. We've even passed a constitutional amendment that you folks will have an opportunity to consider to enshrine in our Constitution our first in the nation status. This goes along with that, even though it may be difficult to enforce it. But nevertheless, it is about protecting to the extent we can in our law that New Hampshire delegates should be treated with the same respect and appreciation that delegates from every other state are treated.
Further questions from the committee? Representative Muirhead.
Thank you, Mr. Chair. Senator, what are the enforcement issues that you see that would make this unenforceable?
Well, the Democratic National Committee is meeting in Chicago, so I would presume that the state of Illinois' laws would apply there, or perhaps federal laws. I think it would be unenforceable as a result. That being said, it's an important message that we send, and it doesn't matter whether it's Democrats or Republicans. We're protecting or trying to protect by making a clear statement that delegates should be seated and have full voting rights, that our primary is important.
Further questions? Representative Weary?
Thank you, Mr. Chair. Thank you for taking my question. So I'm just curious, is that just trying to think through the litigation that would likely result. And if the New Hampshire representatives were not seated, then they would be infringing upon New Hampshire citizens' rights to have our votes considered in that situation. So I'm just trying to think through the possible litigation. Do you see something arising from that? You know, they don't seat our delegates, and then what would happen in that?
Again, I don't think it's enforceable,
Mm-hmm.
but I do think it's important nevertheless.
Okay, thank you for taking.
Further questions? I have a question. Senator, I do share your concerns about it being unenforceable. When this bill was being crafted, was there considered something that is enforceable? So, for example, I take issue with us telling a private organization how to conduct their business. However, we do control the state's 4 electoral college votes. So has there any sort of thing like that been considered?
No, I didn't consider that. I think, again, this is really more about trying to stand up under New Hampshire law that we believe our delegates should have full voting rights and should be seated, and in essence, trying to create the climate, if you will, at the whatever convention is, whether Democrat or Republican. In this case, it's a Democratic convention, that our delegates should be seated. And by sending that message, that's what this is about.
Thank you. Are there any questions, further questions of the committee? No. Thank you so much, Senator. It's always a pleasure seeing you.
Thank you.
We have one other person signed in to speak for this, Colin Tiernan, I'm sorry, from Concord. Make sure you press that silver button right there.
Thank you, Mr. Chairman. Thank you, honorable members of the committee. My name's Colin Tiernan. I'm representing myself. I wanted to speak on my experience as a delegate in 2016 and why I think this is a worthy bill. Even if it's not enforceable, there's still the optics of it. There's still the reality of what delegates go through. In 2016, I experienced delegates spitting, pushing, seat stealing. They sent people to fill seats. There were lights turned off on entire states. There were white noise machines. There were chants of USA, USA, USA over no more wars. And, you know, I'm a veteran. I served in the Marine Corps. I was in Iraq. I had a no more wars sign. They took a giant American flag to cover that up. So it still irks me to this day. Overall, I think it was a pretty toxic and traumatic experience. And if nothing else comes from this bill, that the opportunity for delegates to come back here and talk to y'all about their experience, I think is very worthy. I think that if the delegates are not seated from New Hampshire, that would be a problem for me personally as an American. And I hope it would be for everyone here too. So thank you for your time, and I'm open to any questions, but
I am sure after a statement like that, there will be questions. At a minimum, I will have some. Are there questions from the committee? Okay, I guess I'll start off. I was not a delegate, but I was on the floor. We were probably at opposite conventions. I experienced some of that climatic, let's call it chaos. It wasn't a streamlined process on my side either. Let's say that. So your interpretation of this bill is that this would make sure that basically they can't. Let's just say it's enforceable. We'll put that aside for a second. This would basically make sure that they can't silence you on the floor as well. Is that one of the things you view in this bill?
I think it brings transparency to that whole process, right? Of what happens to delegates once they're there. And one thing I would maybe suggest that could come out of this is having a communication with your delegates afterwards. What was their experience like? Were they treated properly at convention? I see a lot of value here, and I see a lot of need, because I don't think that tends to happen.
Excellent. All right. Any other questions? I hope you hang around, because I'd love to swap some stories with you. I think it would be fun.
Sounds good. Thank you so much.
Okay. Is there anyone else signed up to speak on SB 271? Seeing none, Representative Vakenberg, can you grab that blue sheet for me? And then we will go right into exec. Is Representative Weary back? Oh, he is. Okay. Okay, there is no one signed in to speak. There's no one signed up that didn't speak. So with that, I will close the hearing on SB 271. We're going to take a 30-second pause, or a 10-second pause. Okay, we are going to take a brief recess. Sorry, I was asking the ranking member if she wanted, and Representative Grill, the clerk. His opinion is very important as well. So we will break. How long do you think you need, ranking member? All right, we're gonna break for 10 minutes. You guys want to stay in here? You want to go somewhere? What? Yeah, you can go in there. It's fine. All right. So our colleagues from the other side of the aisle will go in there. And my colleagues from the right side of the aisle, see what I did there, will stay in here. And we'll be back at, we'll say 10:35. Okay, it's 10:35. We've gotten all back, and I don't think anything changed. So, classic government, wasted time, and nothing changed. Going to open the executive session for the House Election Law Committee. First up on the docket is SB 70. So I will move that SB 70. I have to do the off pass motion first. So I will move that SB 70 be ought to pass.
I'll second that, Mr. Chairman.
Thank you. Seconded. And now I will introduce Amendment 2023-1280H. So I'll make the motion to ought to pass that amendment. I need a second.
I'll also second.
Representative Bohm will grab that second. Yep. Right. Can you read my handwriting? 1280H. And now we are on discussion of the amendment. Is there any discussion on the amendment? All right. Well, that was riveting. Are we ready to vote? Okay. The clerk will call the roll on. We are voting on the amendment. We're voting on the amendment.
Representative Bohm,
Yes. Yes.
Representative Perdomo O'Brien? No. Representative Bogert?
Yes.
Representative Inkerberg?
Yes.
Representative Burnham?
No.
Representative Kennedy?
Yes.
Representative Wary?
Yes.
Representative Wood?
No.
No. And Representative Barry?
Yes. Oh, I'm not last. I'm dead last.
Oh, dead last.
I'm dead last.
Um,
I'm voting yes though, but instead.
Representative Lane?
Yes.
Representative Ward?
Yes.
Representative Hamer?
Yes.
Representative Hamblett?
Yes.
Representative Muirhead?
Yes.
Representative Bay?
Yes.
Representative Brennan?
Yes.
Representative Grill, yes. Representative Howard?
Yes.
And Representative Barry. It's coming back to you.
Yes. Twice. Does that mean I get to count? That means I get to vote twice?
That is, so we have 18, that is 15 yeas and 3 nays.
Yep. Okay, with that, the amendment carries. Just so everybody knows, I should have announced this at the very beginning. There will be no replacement for Representative Smith. We got rid of the vacant seat, so this committee is now 9-9. So I should have announced that at the very beginning, but for those scrambling trying to do math, we are now a 18-person committee. So closer to my dream of 13-person committees, but not, we're still a little off. Okay, we are now on to discussion on the underlying bill as amended, SB 70 as amended. Is there discussion on the bill? All right, this is riveting. All right, with that, the clerk will call the roll.
So this is for ought to pass as amended, and Representative Bohm.
Oh, well, we had an ought to pass motion to begin with. We have to remake the ought to pass motion? Oh, I guess, yeah, we do have to do OTPA. Yes, thank you. You are right.
Ought to pass as
You are right. I will make the motion of ought to pass as amended. Can I get a second?
I'll second.
All right, we're on ought to pass as amended SB 70.
And that was,
And now the clerk will call the roll.
gotcha. Representative Bohm,
Yes.
Representative Perdomo O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Inkerberg,
No.
Representative Burnham,
No.
Representative Kennedy,
No.
Representative Wary,
No.
Representative Wood,
No.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamblett,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
and Representative Barry.
Yes.
That is 10 yeas and 5 nays.
Nope, nope. No, it's 13 years.
13 days, right, right.
Okay. With that, we will close the executive session on SB 70. We'll open the executive session on SB 156. I recognize Representative
Me.
Bohm for a motion.
I make a motion of ITL on SB 156.
Is there a second?
I'll second.
All right. The motion is on inexpedient to legislate on Senate Bill 156. Is there discussion on the motion?
Yes.
Representative Bohm, you recognize.
Well, my big problem with 156 is it allows the use of public information or private information, depending on how you look at it, to approve that somebody is real, exists, or whatever. And definitely, I cannot go along with that. Somebody to go into Facebook and whatnot and say, yeah, that person is real because he's got a Facebook account, or that person is real because he's using TikTok or whatever. So that's my main reason for voting ITL on this bill.
Further discussion on the ITL motion? Yes, Representative Brennan.
Thank you, Mr. Chair. I share my colleagues' concerns about privacy. We heard in testimony from the prime sponsor, Senator Gray, that this would be a voluntary program or voluntary exercise for voters to indicate that they would allow the Secretary of State or town clerks or supervisor of the checklist to use this non-public information. And on page 7, line 25, it does say that the Secretary of State shall prescribe an amendment to the voter registration based on the following. And then it goes on to line 27, the Secretary of State may collect additional voluntary non-public information. And so I support what Senator Gray's intention is in this bill to make it a voluntary thing. There is an issue, however, in on page 12, line 19, where it does not specify that the voter would be voluntarily providing this non-public information. I thought you were going to ask a question. I'm sorry.
Oh, no, I can't interrupt you while you're speaking. A, that would be rude, and B, would be outside of our rules.
That is true. So Senator Gray testified that the form would be amended by the Secretary of State to include a checkbox that would make it voluntary. I don't see in this bill that there is that explicit instruction to the Secretary of State in creating the new form to do what Senator Gray intended. So I'm not sure how to go about voting on this particular bill because I do support what the intention is. And I would have to be putting my trust in the Secretary of State to adjust the form to put that checkbox in to make sure that the privacy of our voters is not violated without their explicit approval of using the records that are already in state systems to assist with verifying the identity of their registration, which would ultimately make it easier for voters to be properly identified and verified and get their registration checked off. So.
Further comments from the committee? Yes, Representative Weary.
If I remember correctly, there was a 2016 study that looked at same-day registrants and tried to analyze the data in terms of following up, did people actually, subsequent to that, apply for New Hampshire licenses and things like that. They found that the application rate was something like under 25%. And then following up with those people, there was very little response back to the Department of Motor Vehicles for for responding to that and inquiring in that. So I'm suspect of other means to create voter identities that could be potentially not sort of not enforceable or not realized. So I think, I don't know that this solves any problems, and I think it might create some new ones. So that's my comment.
Further questions, comments from the committee? Okay, I have mine. I share Representative Brennan's concerns. Maybe we look at it slightly differently. I look at this as that this could be this non-public information that may be used. The question I have is, can it be used for voter list purges in the future? If we don't find anybody on the rolls, can we then take them off because we have this non-public information? For those of you who were paying attention last year, that was something that was proposed, very similar to this bill in front of us. So, if you're into that sort of deal, this probably opens the door for you to do that. But I know there's many members who are not into voter list purchase. So having said that, and no one else wanting to comment to my comments, I assume. All right, then the clerk will call the roll.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Inkerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy,
Yes.
Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
No.
Representative Ward,
No.
Representative Hamer,
No.
Representative Hamlet,
No.
Representative Muirhead,
No.
Representative Bay,
No.
Representative Brennan,
No.
Representative Grill, no, Representative Howard,
No.
and Representative Barry.
Yes.
9-9.
9-9. Is there another motion that would like to be made? Retain is an option.
That's interesting.
Did I throw you for a loop on that one?
You did.
Do you want to? Would you like to retain this bill, Representative Lane? Would you like to caucus and retain this bill, or would you like to?
I think we should caucus.
All right, we will caucus. I'm
sorry.
going to give you.
Okay, never mind.
Oh, she has taken her lead from the honorary vice chairman, Representative Muirhead.
The guy jumping up and down the seat. Yeah, I will move to retain.
Is there a second? All right, Representative Muirhead seconds. Is there discussion on the retained motion?
I'll speak to my motion. I think we all agree with the privacy concerns, and it gave us great pause. What drove us in our caucus to vote for the bill was the voter registration piece and cleaning up this bill, because taking out all the stuff that has been ruled unconstitutional. We are still concerned about the privacy issues. So I'd like to retain it so we can address those and perhaps work with the primary sponsor to fix that language.
Further conversation on the bill? Representative Bowman, would you like to be recognized? You seem like you're moving towards the button, so I figured you wanted to say something. Okay. These new glasses, I got the eagle eyes. Yes, Representative Weary.
Just had a question. Is this the same thing that the Supreme Court actually ruled on after New Hampshire? So New Hampshire ruled some of this unconstitutional, but then the Supreme Court ruled on a similar issue. Is this, or am I mixing up issues?
So yes and no. Yes, as all things in election laws, yes and no. So one of the rulings in SB 3, which was a 3-2 decision from the New Hampshire Supreme Court, was that basically combating voter fraud was not enough of a compelling state interest for the measures provided in SB 3, particularly the language in the documents they had to sign, the length that it would create in voting locations, that the state's interest in combating voter fraud or perceived voter fraud, whatever you want to call it, didn't weigh enough to allow for the provisions in SB3. The day before, the U.S. Supreme Court, in a decision I think around North Carolina, said the exact opposite, which was the state does actually have a very compelling interest in fighting voter fraud, even if it is perceived voting fraud. So I'm sure at some point our esteemed court system is going to have to deal with that. The U.S. Supreme Court decision came out on a Thursday. The New Hampshire Supreme Court decision came out the Friday, literally the day afterwards on Friday. I know because I was going on to Close Up on WMUR to talk about a U.S. Supreme Court case, and I got to talk about a New Hampshire Supreme Court case I hadn't read yet. So that's why that's why the dates are ingrained in my memory, because it was awkward. So I hope that sufficiently confused you with the question that you asked. I will be since I'm already talking. I will be supporting the retained motion. I do have privacy concerns issues. I'm not necessarily against cleaning our voter rolls. I am against using things like Facebook and TikTok to clean our voter rolls. So it's a one is against. It's one of those. It's election law, so it's yes and it's no. So retain is a great way to yes and no this bill.
It's like improv.
Are there any other comments, questions, concerns on the bill? All right, seeing none, the clerk will call the roll. We are on the motion to retain SB 156.
Representative Bohm,
Yes.
Representative Perdomo O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Inkerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy,
Yes.
Representative Weary,
Yes.
Representative Wood,
Yes.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamlet,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
Representative Barry,
Yes.
18 to none.
Okay, and with that, House Bill 156 is retained. I'll be closing the executive session on House Bill 156. I'll be opening the executive session for SB 157. I'll recognize Representative Lane to make a motion.
I would like to make a motion ought to pass.
I will second that motion.
And
And then Representative Lane, you are recognized again.
I am. I would like to submit an amendment, which I think all of you should have copies of. It's Amendment 2023-1385H.
And I will second that motion. We are now on discussion on the amendment 2023-1385H. Is there discussion on the amendment? Representative Lane, you're recognized.
So what we did is we went through what was provided to us at the hearing and testimony, and we removed certain things such as the reference only to AccuVote machines. We've expanded the number of places to 8 wards instead of 4. We've also gone to only having, instead of basing the number of ballots on a percentage, we've done 100 ballots and per location, and I'm trying to think what else. But those were the changes that were made. They're based on the questions that even though I wasn't here, I did watch the tape, and I based it on the questions that came from from our committee, and then worked with some of the folks who made those suggestions to draft this amendment.
Further comments or questions on the amendment? Representative Bohm, you're recognized.
Yeah, I agree with Representative Lane's thing on from the hearing last week. And I brought this up too. Why just AccuVote machines when we're going to be changing them, and we have to come up with another bill to do it again? So yeah, I agree with the amendment. Thank you.
Further discussion on the amendment? Seeing none, the clerk will call the roll. The vote is to pass pass the amendment pass the amendment of 2023-1385H onto SB 157.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy,
Yes.
Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamblett,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
Representative Barry,
Yes,
18-0.
we did it. Representative Lane, would you like to make a motion of ought to pass as amended?
Yes, please. Ought to pass as amended.
All right, and I will second it. So we are now on discussion on ought to pass an amendment on SB 157 as amended. I probably stuttered through those words real bad. I'm having a day. Okay. All right. Seeing no discussion, the clerk will call the roll.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy,
Yes.
Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamblett,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
and Representative Barry,
Yes.
18-0.
Okay, and with that, SB 157 will be sent out of committee as ought to pass as amended. Oh yes, consent calendar. Would anybody like to make the motion to put it on consent calendar? As Representative Akenberg so moves. Was anybody opposed to that bill going on consent calendar? All right, seeing none, it will go on consent calendar, where all bills should go, irregardless of the first one will not go on consent calendar. All right, I'm going to close the hearing on Senate Bill 157. I'm open the the executive session on Senate Bill 158. Representative Burnham is recognized for a motion.
Thank you, Mr. Chairman. Yes, I'd like to make a motion to ITL SB 158.
Is there a second?
Second, please.
There is a second. Is there discussion on the motion of inexpedient to legislate on Senate Bill 158?
Sure.
Representative Burnham, you made the motion. You
Okay.
go first.
I just wanted to make a couple comments. Being involved in my local elections over the last 10 years, I can understand, especially in 2020, the concern of time and opening absentee ballots. However, there are other officials there that are able to assist in opening that outer envelope. By allowing the town clerk to have the opportunity to open that outer envelope as it's mailed in, just leaves a lot of room for suspicion. And I and doubt in the integrity of the absentee ballots. And also the process of someone handing in an absentee ballot without the outer envelope also raises concern, because then other people may see that that is an absentee ballot and it's not protected by an outer envelope. So to me, I just in order to save time, I don't believe is enough of a reason to unprotect the absentee ballots by removing those outer envelopes ahead of time.
Representative Lane.
Thank you. I'll be voting against the motion for ITL, but I do want to highlight the fact that when Senator Gray spoke to us, he stated that this bill would fix both of the issues that were raised in the court order that necessitated this bill. And I am not sure that I agree with Senator Gray. In fact, when I don't think it really addresses the signature verification piece of it. And it's in section 5 of the bill. It doesn't substantially change the existing statute. So I want to go on record that it does not address, at least for those of us who will be voting for the bill, this does not address the signature verification process that's set out in the court order.
Further discussion on the bill, on the inexpedient legislative motion. Yes, Representative Kennedy.
Am I mistaken, or does this not specify when the envelope can be opened?
That was going to be a point that I was going to raise. Is there any further discussion before? I guess that that's kind of the nice part of being chair. You kind of get like the last salvo. All right. So let me discuss my issues with this bill. To Representative Kennedy's point, we've heard pre-processing bills before, and they've always been done inside of a window, right? There was a noticed window, and you could go and you could show up and you could watch the ballots be taken out of the outer envelope and marked off the checklist. And that was a transparent process that was allowed to take place. It was noticed. It was noticed when you had these changes during COVID. It was noticed. You could go in, you could watch it. Pre-processing bills that this committee has dealt with before all had a time and a date for that, right? So it was like 3 days before the election, the week before the election, whatever. This bill does not provide for that. This bill says those things are getting opened as they come in. So we lose that transparent process. I don't know why that is done. If the point is to speed things up on election day, you could easily have put a window in there that has been done before. It seems like it was almost intentionally left out. My second point, to push back on my colleague, the ranking member's statements, this does open the door for signature verification. And in fact, if you listen to the testimony, the bill sponsor said that the Secretary of State office will provide training for signature verification, and that by removing the word shall, you have changed the language of the statute. The state spent $3 million defending SB 3. I imagine that we will see something like that with that language change, but by changing that language, we are touching the language around signature verification, and with the testimony given about training for signature verification, this bill will allow for signature verification. It will not be compulsory because the word shall is being removed, but it will be an option. So if you're voting for this, you will be supporting a form of signature verification because that is what the sponsor of the bill said, and by changing that language, that is clearly their intent. So I guess there's, once again, election law. There's things you like and things you don't like. I don't like that the absentee ballots are going to be opened up before election day. I don't think it's necessary. I definitely don't like that there's not a definitive window for that. But I do like that we're going to go back to some signature verification. And if those things are not signed correctly, it looks like, I guess they'll have a chance to fix them. But the testimony and the bill are very clear. This would allow for signature verification, at least in my interpretation. Representative Lane, I'm sure you will refute that.
Yes, Mr. Chair, I will. I think just taking the word shall out of the sentence does not change the intent. It commands the moderator to do so in certain situations. And I think the shall in here is superfluous. And I do not think that it changes the existing statute to address the court order. But I'm not a judge, and we'll let a judge decide that.
Spoken like a lawyer, a true lawyer, a very good lawyer, by the way, a very good lawyer. Representative Lane's a lawyer. That's not an insult. Representative Lane's a lawyer. She's an attorney. My response to that, Representative Lane, would be, if we didn't have to change it, then why did he change it? He changed it for a reason. He changed it for a reason. And he changed it, per his testimony, to open the door to signature verification. That's what he said, and that's why he's touching that law. Nothing else. There's no other reason, to your point of being superfluous, there's no other reason to change it other than to reopen the door to relitigate it, because the goal is to get to signature verification. Representative Ware, you're recognized.
Yes, thank you, Mr. Chair. Yeah, just the whole transparency thing is concerning because I think we've passed almost unanimous bills this session that provided mechanisms for clear public observation of events, and granted at the tail end of the election process, and to allow something that then would remove that at the front end of the election process is a little bit disturbing. So I think it's hard for me to support something that goes against the fundamentals of things we've passed earlier this session.
Okay, Representative Lane. See, this is a lively one. I like this one.
I guess I would like to ask a question about removing the outer envelope in certain circumstances. Is that a no-go, or is that something we could work with?
Was that question directed at the committee? Okay, at the committee as a whole. We'll let Representative Weary answer first, since he moved towards his microphone.
So in another industry, I've done a lot of data integrity audits, and chain of custody is a very important aspect. And by separating the affidavit envelope from the rest of the vote, you're really you're removing an element of the chain of custody at that point. And so I think that undermines the very aspect that we would endeavor to seek for election integrity. So I have concerns about from that perspective.
Can you repeat your question, Representative Lane?
Can I?
Yes.
I was wondering if the fact that we had no outer envelope when, for some circumstances, was that something that could be acceptable or worked around? In other words, is it just a flat no-go that we wouldn't be able to solve that by retaining the bill?
I can speak for myself personally. I cannot speak for the committee, obviously. I don't have a problem with getting rid of the outer envelope. I have a problem with handling election materials in an unsupervised way. It's not transparent. And I know we disagree on this, but I like election day to take place entirely on election day. Barring that, I really have objections with it being handled in an indefinite period. In terms of your direct question to the outer envelope, I've actually kind of often wondered why we have an outer envelope, because it just seems like something that we pay for. But I don't know. Once again, it's a yes and a no, and I hope I sufficiently confused you. If you're offering to retain the bill, I'm happy to vote for a retaining motion. But first, we'd have to vote on the underlying motion of inexpedient to legislate, and then we can retain it. But you'd have to let me know if you wanted to retain it.
We have to vote on the motion for us.
Okay. Well, we know how we're going to vote on the motion. So. Okay. It's the day of caucuses. Representative Brennan.
Thank you, Mr. Chair. I agree that the outer envelope, there is a cost to that if it is not really a necessary thing for every single absentee ballot. We are paying for outer envelopes that we don't actually need. And so I think there is some room to have discussions about the necessity of the outer envelope while maintaining the integrity of the ballot and that process. But if I may make a second point regarding the signature verification and the training that was brought up by the Secretary of State and what they would be offering. It's my understanding that signature verification training is intensive, and there was no indication from that I can recall from the Secretary of State's office that they would be providing the intensive signature verification training that would be required to conduct signature verification activities for each and every ballot that is received. There is nothing that I can find in this bill, and please point it out to me if I have skipped over it, that indicates that training on signature verification is part of this. So while training has been discussed, the bill itself does not require the Secretary of State to conduct any kind of training whatsoever on signature verification, whether it is compulsory or otherwise. I do share the concern that opening the door for signature verification is not a door that many of us would like to open. But I do not see the language in this bill that opens that door. And as has been stated, it would be up to the courts to find that door if it was cracked open, or if it is entirely shut, as the bill does not indicate that door would be opening.
Fair enough. Representative Burnham.
Thank you, Mr. Chairman. I have a question since you've had absentee ballots sent to your home. Yes? So
Yes.
the outer envelope, does it have any information indicating that there's an absentee ballot in the envelope?
Oh, and it's pretty obvious.
The outer envelope says
Yeah.
absentee ballot?
So the outer envelope that you send in actually says election materials, and the reason why that's important is because in 2020, when we had a slew of absentee ballots, 33% of New Hampshire voters voted with an absentee ballot. The U.S. Postal Service actually said we will deliver election materials without postage on it, which was a point that I when we had the postage bill that came forward, I actually was stunned nobody made, but I wasn't going to help. So yes, it is clear what's inside. It says election materials enclosed, I believe is what it says on it. Now I'm a little fuzzy on that. I've been voting in person for some time, but
And does the absentee ballot envelope say absentee ballot on that envelope?
it says election materials
still
enclosed.
election
Yeah, which
materials.
is, I mean, a rational person would gather. You know,
On
it's
both.
like I wasn't speeding on 93 this morning. I was going fast. Um,
I'm just curious because I'm assuming that it is done for the purposes of protecting the ballot, for having the outer envelope.
I believe I you know, I don't know why we've had the outer envelope before. To be honest, I don't know why. The only thing that I could kind of think of is like it's another layer of protection, like if it gets wet or something spilled on it, which is certainly with my messy house is a possibility. Well, he's not running yet, but he's working on it.
So because I have assisted in opening ballots on election day in public. So we were only told to open the outer envelope and to take the absentee envelope, open it, but not to take anything out. That was the process to help with the increase in the absentee ballot. It went very smoothly and quickly because there were several of us that were elected officials to do so in assisting the town clerk. I'm just wondering why there would be an outer envelope in the first place if it's not for the protection of the ballot. I'm assuming that's what it's for.
I think we'd have to speculate. I can't give you a definitive answer as to exactly
Okay.
why it's there.
And well, that's just what I'm raising. There's a reason for that outer envelope. And really, if there's such an increase like we've seen in 2020, there are means of assisting the clerk to advance that process. And there was no delays.
Well, to address the last part about the increase in absentee ballots, the absentee ballots have largely gone back to pre-pandemic levels. They're still a little elevated. I think it's like 2 or 3%, but it's not like normally in a normal election, New Hampshire election, absentee ballots count for anywhere from 10 to 15% of the overall vote. And some of that, by the way, does depend on the partisanship of the district that it is voting. And so you can kind of predict like what turnout's going to be based on what absentee ballots look like in terms of like who has requested one, who's returned them, that sort of deal. But to your underlying point, we're kind of back down. We're like 2 or 3% above where we were. 2020 was obviously an irregularity, right? Like a third of our voters voted with absentee ballots, and in some municipalities, voting locations, that was an over 300% increase. Right, we're not in that anyway. So if that's, I guess my statement to you would be, if that's part of your calculus, don't make that part of your calculus because we're kind of already moved past that. At least the voters have.
Right. So what is the point of the bill?
Yeah, that's why we're here. What is the point of the bill? Representative Weary.
just to tack on to what Representative Brennan said is, we've heard the Secretary of State's office testify that even though they conduct training, it is poorly attended by a third of what they would have anticipated. So even if they did provide signature verification training, extensive in whatever form, it is unlikely that we would have large groups who are properly trained and educated in that verification process.
Okay. Resident Bowman, then I think we're going to wrap it up because I think we all know where we're at here on the ITL motion. Then we can have a quick caucus and figure out what we want to do from there. Resident Bowman.
Yeah, I just want to verify, state the same. I believe it's for protection of the ballot. How many of you have gotten mail that's been opened? I mean, just because maybe it wasn't sealed right or whatnot. So I think it's a good protection for that outer envelope to protect the absentee ballot.
All right, and with that, I'm going to call a close to our very lively conversation. I did enjoy it. And the clerk is going to call the roll. We are on the motion of inexpedient to legislate on Senate Bill 158. The clerk call the roll.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy, Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
No.
Representative Ward,
No.
Representative Hamer,
No.
Representative Hamlet,
No.
Representative Muirhead, Representative Bay,
No.
Representative Brennan,
No.
Representative Grill, no. Representative Howard,
No.
Representative Barry,
I'm yes.
9-9.
Okay. Would you like to caucus briefly? Okay. You guys take it in here. We're going in there.
Okay.
All right. 5 minutes. It shouldn't be. We can't. I don't. Did you hear us when we were over here? Oh. It wasn't very riveting, was it? I don't. You can go to wherever, or you can take this room, and I can take my guys down to 300 if you want. You want to do that? Yeah. All right. So. Okay, we will reconvene. We'll be in recess until it's 11:17. So let's give us till 11:25. We'll reconvene 11:25. Republicans will join me in my very messy office down the hall. So the bill is now open to a further motion. Representative Lane, you're recognized for a motion.
Thank you. I'd like to move to retain SB 158.
Is there a second to the motion to retain?
Second.
Representative Ward is a second. Is there discussion on retaining the bill?
I'll speak to my motion.
Okay.
So again, there's issues with this bill. I know they're trying to solve some problems, but I want to make sure that we do it in a way that the committee is satisfied, that it addresses many of the issues that have been raised. And I'd like to also find out, why the second envelope is required and get some information from the Secretary of State and work on the language about the signature verification. So.
Okay. Further discussion? Seeing none, the clerk will call the roll.
Representative Bohm,
Yes.
Representative Perdomo O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
No.
Representative Burnham,
No.
Representative Kennedy,
No.
Representative Wary,
No.
Representative Wood,
No.
Representative Lane,
Yes.
had me in suspense.
No, I
Representative,
was kidding.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamlet,
Yes.
Representative Muirhead, Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
Repre-
Sorry.
Representative Barry.
Yes.
That is 13-5.
Okay, and with that, House Bill 158 is retained. Closing the executive session on House Bill 158. Opening the executive session on Senate Bill 158. Opening Senate Bill 271. Is there a motion?
Mr. Chairman,
Yep. Representative Aikenberg, you recognized.
move ITL on Senate Bill 271.
Okay. Is there a second?
I'll second.
All right. The motion is on inexpedient to legislate on Senate Bill 271. Is there discussion on the bill? Representative Aikenberg, you're recognized.
Yeah, so we just heard the Senate President address the committee. He basically insinuated and told us that this bill is totally unenforceable, so I'm not really sure what we're doing here. So we should kill it.
Representative Howard, you're recognized.
Thank you, Mr. Chairman. I want to echo the points that Representative Akerberg just made. I think that this is just something that would clear, they would create space in our statutes, and we don't need that. So I'm going to be voting for IT.
Very conservative argument to save ink. Any other, would anyone else like to speak to this bill? I will be joining my colleagues in voting in speech to legislate. It is just as a broader statement about what's going on with the National Convention. This could be happening to either party. The old campaign guy in me wants to sit here and like, oh, how do you do this? The reality is this could be very well my party trying to circumvent this process as well. So I guess my message to the committee along this bill, along any bill dealing with First Nation is we need to explore options that actually have teeth. This is a toothless option. Are unconstitutional, and God forbid if the AG actually tried to enforce it, I actually believe it would further erode our strength in the national, in the First Nation primary, because it would establish rights that the parties currently have that have not been adjudicated. It would set those in stone. So we need something that has teeth. This isn't it. This has no teeth. And Representative Bone, you recognized.
Yeah, just if I remember right, over my many years, this happened once before with the Republican Party. And it come to the end after they said they wouldn't be seated, they voted to seat them. So this bill is not necessary.
I have a long conversation about how I don't think just not seating the delegates is going to be what they do this time. This time, I think what they're going to do is I've been talking about it for 6 years. Everybody thinks I'm crazy, and that's okay. I think that what they're going to do this year is what's called the poison pill amendment. which nobody in the New Hampshire media will talk about. But what I believe they will do, and I could be wrong, is they will not seat New Hampshire's delegates. They will say any candidate who puts their name on our ballot will not have any delegates. And in that case, we would conduct the First in the Nation primary, but there would be nobody running. So that is what I think what they're headed to. This bill doesn't do that. This bill doesn't solve that problem. We, as a committee, need to get together to figure out how to solve that problem in the interest of New Hampshire, but that is not going to be what the party is about to do. At least what I believe they have to do would not be our law will not protect us from what they're going to do, because it will, in effect, we will have no primary. We will physically conduct the election. There will be no one on the ballot. With that bombshell, we will call the roll.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy, Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamlet,
Yes.
Representative Muirhead, Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
Representative Berry,
Yes.
18-0.
Okay, is there a motion for consent, or do we want to debate this on the floor?
I'll second yours.
I make a motion for consent.
Okay.
And I'll second it.
Okay, and with that, we'll put it on the consent calendar. And then, so with that, SB 270 will come out of committee as inexpedient to legislate. We're going to close the executive session on Senate Bill 271, and we will open the the executive session on SCR 1. And I'm looking for a motion. Representative Wood makes a motion.
Yes, thank you, Mr. Chair. I'd like to move SCR 1 to OTP.
Ought to pass. There's an ought to pass motion. Representative Howard, would you like to make the second to that motion?
I would.
Okay. Is there discussion on the ought to pass motion? Representative Wood.
We could discuss about the value of a resolution all we want. Did get a chance to look at First in the Nation, and clearly after looking at a lot of material last night, there's only one state that can claim it. If I was in charge, I'd make sure we wouldn't lose it. Nobody else can take it away from us, from what I can see. And I would like to go through the motions and support any effort that's done along those lines.
Further discussion? Representative Ankerberg.
Thank you, Mr. Chair. I would just point out that looking at this resolution, we had all 24 members of the Senate in support. I would hope that as to the Senate President's sentiments when he came and testified this morning on 271, this is the statement in support of the First in the Nation primary status for New Hampshire. I think it gives New Hampshire citizens a voice in a larger national discussion. It's very important that we're recognized as being first in the nation. I'll support this. Thank you.
Okay. Further comments from the committee? Seeing none, clerk will call the roll.
Representative Bohm,
Yes.
Representative Prudhomme O'Brien,
Yes.
Representative Bogert,
Yes.
Representative Ankerberg,
Yes.
Representative Burnham,
Yes.
Representative Kennedy, Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Hamer,
Yes.
Representative Hamlet,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Brennan,
Yes.
Representative Grill, yes. Representative Howard,
Yes.
Representative Berry,
Yes.
18-0,
Excellent.
consent.
I'm going to keep it off consent for right now. I think it's actually, to Representative's point about all 24 senators supporting it, I think it's important that we have a unanimous vote on this in the House.
Yeah.
And that's not on consent calendar. So I'm going to keep it off consent.
Okay, but no minority, no.
There will be no minority report, but it will not be on the consent calendar. I think this is an opportunity for us to come together. With that, I'm going to close the executive session on SCR 1. Representative Brennan, you are pointing.
Yeah. I have a point of order.
Okay, yes.
Do we have to vote on the amendment to 270?
270?
Not to 271, I'm sorry.
No, because it's not brought forward.
Okay, just checking.
Nope. We already acted on the bill, and it's nobody felt the need to stand up for the primary.
So who's writing the minority report for 70?
I'll take care of it.
Wait,
For 70.
yeah, and the 5 who didn't.
Oh yes, actually, thank you. We do need to get the committee reports here. So let's go through this real fast. SB 70, Representative Lane, I believe that's your wheelhouse, or do you want me to take that? That's, all right, I'll take care of it. I'll take care of SB 70 since it's my amendment. The minority report, Representative Burnham, I believe you voted in the negative. Can you do the minority report for SB 70? You don't have to, but it's the opportunity. SC 156 was retained. SB 157, Representative Lane, I am going to give you that one. That horrible consent calendar bill. It's really a lot of lift there. And then SB 271 was another consent calendar bill. I need Representative Aikenberg is going to do that. And then SCR 1. Oh, you want to do that one? All right. Please, you know what? He wins. You know why? Because he's already done it. So if everybody could get me those, preferably by the end of the week, I think. I'd like to just get this in. This, I was trying to see, I do not believe we have any more bills. I was trying to see, I knew that there was the Senate's version of a CACR but I have not taken possession of that bill. So I don't know if it's coming to us. So my hope is that this is the last time that we're meeting until next year. If we do have to get back, not that I don't enjoy seeing all of you.
We have to do the retained bills.
Well, we have to do the retained bills next year. They're
We have to
retained.
do them this year for
Oh, we
next
have to-
year.
Oh, we have to,
To meet this year.
yeah, we have to meet in the fall. Sorry, yeah. Yeah, we'll see. I'll see you this year. We'll see you in the fall. And then, but if we do meet, if we do get that CACR, whatever they call it, my intention is to do a SNAP hearing, and a SNAP executive session during lunch while we're in session. My gut is that since that we have not gotten any lengthy testimony about the presidential primary bills to this date, and we all just took 2 unanimous votes, that we could probably grind through that in about 5 minutes. Because you know how I feel about lunch, which it is time for lunch. So I will see you all in the fall and in session, and maybe one more time.
And I believe that CACR is to put the
Yay.
delegate in the Constitution.
All right.
Do you need any of the totals?
I just need to know the reports.
Yeah.